Hello and welcome to Rights and Recourse, the program that educates you about your rights and recourse to those violated. My name is Dumila Matez. We come to you live from Studio 10 today. We've got a little bit of a gremlins in our system here at the SABC. But 16 years ago, on July 17, 1998, 120 countries adopted the Rome Statute of the International Criminal Court, still be known as the Rome Statute, establishing the International Criminal Court for the first time in the history of humankind. States decided to accept the jurisdiction of a permanent International Criminal Court for the prosecution of perpetrators of the most serious crimes committed in their territories by their nationals after the entry into force of the Rome Statute on July the 1st, 2002. Sadly, though, despite this noble step by the world, some states, for reasons known to themselves, decided not to ratify the Rome Statute and decided to stay outside global jurisprudence. The African Union on October last year at a special assembly in Addis Ababa adopted a resolution that all heads of state cannot be indicted by the ICC whilst in office. On Rights and Recourse today, we take a closer look at the International Criminal Court and its difficult relationship with human rights in Africa and the world. To discuss today's topic, our Professor Shadrack Guto will join us later from the University of South Africa Center for African Renaissance. At our Durban studio, retired Judge Navanathan Navi Pillay, immediate past United Nations High Commissioner for Human Rights, and at our Bloemfontein studios, we have Mr. Pakiso Muchochoko, Director Jurisdiction, Complementary and Cooperation Division from the International Criminal Court. But before we get into this discussion, let's listen to a speech made by retired Judge Navi Pillay, an extract from her Steve Biko lecture.
A life cut short, and yet a life that not only contributed to the dismantling of apartheid in South Africa, but also informed international human rights norms and standards. Amongst these was the decision referred to by the Vice-Chancellor by the UN Security Council to ban arms sales to South Africa in November 1977. Just before I left, I had occasion to meet with the P5. They hosted me to a breakfast, you know, the big powers with the vote. And I said to them that I thought the veto was misused many times. Apart from Syria, where I was calling for referral to the ICC, I reminded them that for this vote on the banning of arms sales to South Africa in November 1977, three of the big powers, United States, UK, and France, used their veto to stop action against the apartheid government. So I said that directly to them, because that's the power of my mandate. I had 2 days left, so nothing to lose. Because death also served as a catalyst towards finalization of the UN Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. I do hope that South Africa will get on with ratifying the optional protocol to the Torture Convention so that individual complaints about torture can be heard by the Committee Against Torture. Now, the action that each of us can and should take against human rights violations wherever they occur is, as Biko himself urged, not to be a spectator, but a participant. Just as individuals around the world cared about anti-apartheid activists and human rights defenders like Biko and demanded that their own governments support our struggle for freedom, so we should watch out, use our voices and speak out, and demand that our own government supports the safety and freedom of human rights defenders, journalists, and NGOs who are facing arrests, detention, and even death for their critical work, both at the hands of their own governments and by drug lords and other criminal elements.
Welcome back, and as you heard there from Judge Navi Pillay when she was delivering the Steve Biko memorial lecture. Probably the first question, Mr. Mchochoko, I should ask this question from you because you are the incumbent at the ICC. Probably the first question should be, what is the International Criminal Court and how different is it from the World Court that used to be at The Hague too, that was adjudicating on geopolitical differences?
Thank you very much, Timile. As you rightly pointed out in your introduction, the International Criminal Court is a court that was established through the Rome Statute. It is a treaty-based institution, meaning that states voluntarily adhere to the ICC statute and in order for them to be bound by the treaty provisions. Now, unlike many other courts, the court has only got jurisdiction in respect of a limited number of crimes. These are serious crimes, crimes of concern to the international community. These are war crimes, crimes against humanity, as well as genocide. Now, the main difference between this court and other courts, in particular the ICJ perhaps that you are referring to, is that the court is about individual criminal responsibility. It is not about dispute between states. For a very long time, individuals carried out these crimes, and there was nothing that could be done against them. And they always hid behind state authority, sovereignty, and many other excuses. And as a result, we had these crimes being perpetrated with impunity. It was therefore in 1998, following a long discussion and very, very long consultations, in which all states, including all African states parties, participated. And they came out to say, there shall be no longer impunity. Anyone, irrespective of the status, who commits any of these crimes must be held individually criminally responsible. That is how the ICC came about, and that is what the ICC is now doing. It is intended to contribute to international peace and security by holding those responsible for these crimes criminally, personally accountable. It is only through holding people personally accountable that the hope is that we can bring an end to this criminality and therefore bring peace to the world all over and stop the violation of the human rights that we have seen all over the years. Unfortunately, even though this is the state responsibility, history has shown that states themselves, which have responsibility to investigate and prosecute these crimes, over the years, states have failed to do so. Therefore, still realizing the sovereignty of states to investigate in these crimes, the ICC statute provides that the ICC will only intervene if a state party itself is either unwilling or unable to investigate and prosecute these crimes. So the first bulwark against impunity is in fact the states themselves. And it is only if the states themselves are not investigating and prosecuting these crimes that the ICC will intervene.
Mr. Mchochoko, I just want to go down to Durban, to Judge Pillay. Judge Pillay, sadly, as we said in our introduction, some countries decided not to ratify the Rome Statute. Why?
Well, firstly, they don't say why they're not ratifying. Clearly, the thinking is that they don't want to be accountable at the highest levels, so it's to protect themselves. As Pakiso just explained, this is a treaty body. The court only has jurisdiction over states who have ratified, but the Security Council has the power to refer these serious situations to the court. As I spoke with governments in the Middle East, Asian states, and United States, they are concerned about their respect for immunity for their heads of states. And the United States, for instance, has a special clause that they got other states to agree to, which is that no US soldier will be brought before the ICC. So very large states, the United States, India, Pakistan, Indonesia, and China, Russia are not parties to the Rome Statute.
That's where my problem is. You were saying, and I think the chief prosecutor at the ICC was saying the same thing during the week, that some recommendations or referrals can be made by the Security Council, but unfortunately the majority of the countries or states that are sitting on the Security Councils are not signatories to the Rome Statute. How then can the Security Council be a referral body to the ICC?
Well, that's in the Rome Statute, and in each case where the Security Council, together with members of the P5 who are not members of the ICC, wherever they made decisions of referral, these include Sudan, that's Darfur, and Libya, these were at the request of civil society all over. They felt that there has to be accountability for the very serious crimes being committed in those two areas, that international criminal justice could not reach those places because they were not parties to the Rome Statute. And so it's the appeal of people and victims who want justice, who appeal to the Security Council to refer those situations for investigation. And you know that the prosecutor of the ICC begins as an insight into the facts, but has to take that investigation to a pre-trial chamber of 3 judges. So it's an independent judicial decision on whether the ICC should begin investigations and prosecution in those areas. So those are the checks and balances against any political decisions being made.
Mr. Chochoko, are the trials that are being handled by the ICC similar to the trials, the Nuremberg trials of 1948, or is there a difference between those trials and these trials that are being held now?
Well, to the extent that individuals are held criminally individually responsible, these trials are similar. In fact, most of the principles of individual criminal responsibility and the crimes that were defined in Nuremberg are the same crimes that we are defining now. What is now happening, at least with the ICC now, is that the ICC only has got jurisdiction over states that have ratified the ICC statute, or over nationals of states parties to the ICC statute. Unlike in Nuremberg, which was mostly seen as a victor's trial or as a victor's justice, where the victors themselves just chose who to investigate and prosecute. Here at the ICC, there's a clear judicial process. There's a clear mandate of the prosecutor, who has been given this mandate by the 122 countries that have ratified the ICC statute, and said to a prosecutor, if any of these crimes are committed in our territories, we ask you to intervene and investigate and find out who has committed these crimes and bring those persons to justice. So that is the difference that you have between Nuremberg and the ICC now, is that states here voluntarily join the ICC. If I may just add to what Navi was saying, the ICC
we'll come back to that. You can add that when we come back from a break. We just have to go to a break. If you'd like to join us on today's discussion, please call us on 011 714 6918 or 6919, or tweet us at Rights and Recourse. We'll be back after the break.
I once saw a flower blossom through 27 prison bars of yesterday's unjust flames. I felt an old woman's anticipation for the country's first open elections. And I heard the loud celebrations of that flower's historic inauguration. I was there when Unity sang of how the Springbok never held anything back, and we saw a first-time band of 11 men, Shibobo possibility throughout the land. At the foot of Africa, time remembers how truth can reconcile a people. We carved our name into space, and on the world stage, our art stood united. When we blow that vuvuzela, the whole world goes into a trance. And even in that tearful hour of the flower's separation, we are a people who see the music and hear the flowers dance. SABC, sharing 20 years of inspiration.
SABC News delivers stories
that unify the nation
in many ways. Stories that inspire us
to see the world differently, appreciate
and celebrate our diversity.
And mostly,
they make this place a better country to live in
despite our color,
beliefs
or culture.
I
am
Mahendra Raghunath.
Tabile Ngwado.
Lulu Kabu.
Join us every day
as we provide updates on
local and international news
straight into your home.
We
are
SABC News.
Welcome back. Judge Pillay, you mentioned earlier that the US has made it a condition that no US soldier will be brought before the ICC. Isn't that a problem, though? Because we have seen some heinous crimes done by US soldiers in Iraq, for instance.
Many civil society actors, and mainly from the United States, have objected to the US position on this, because the ICC will only be successful if all states participate in that. And as Pakiso said, the primary responsibility for prosecution is with the national authorities. And here I must point out that of all the states, the US authorities in particular do place their soldiers on trial for suspected crimes. They do attend to national prosecution. On the other hand, they should be parties to the international process, because many of their soldiers do commit very highly serious crimes, which are allegations and should be investigated and prosecuted, in the same way as the ICC is investigating and prosecuting these 4 serious crimes: genocide, crimes against humanity, war crimes, and very shortly the crime of aggression. And states, especially state authorities, should take responsibility for the commission of these crimes. What I found objectionable is how much pressure the United States authorities placed on other governments, firstly, not to ratify the Rome Statute, and secondly, to sign written undertakings. If they are to receive aid from the United States, they had to comply with this condition, that they will never hand over any US soldier to the International Criminal Court, any US soldier found on their territory.
I don't want us to make this a discussion about the US and the ICC, but it would seem to me you must have received during your term as the Commissioner for Human Rights at the UN complaints about Guantanamo Bay, for instance.
I certainly did. And as High Commissioner, I pledged that I would attend to all rights of all people all over the world. I've issued public statements on Guantanamo, and particularly calling on President Obama to comply with his own undertaking that he will close Guantanamo. And he made that statement 2 years ago. I also acknowledge that actually there are many obstructions in the way of the president, which comes from his own Congress and Senate. We have documented the individuals on Guantanamo and other detention centers that come under the US, the fact that they're being held for long terms of detention. Some of them will never be brought to trial because there is no evidence against them. This is conceded by President Obama himself. So it violates all rights of freedom, of fundamental freedom of individuals, for them to be held in detention when there is no intention of putting them to trial. So I say either try them or release them. Some of the individuals were actually youth, youngsters. I don't have my records right now, but there's a teenager who was held for 7 years, for instance, on Guantanamo. The special rapporteurs, the experts established by the Human Rights Council, have asked many times for access to visit and talk to the detainees in Guantanamo, and even that has been denied. So we need transparency and we need release of those detainees.
I just want to ask both of you this question. Probably I want to start with Pakiso first in Bloemfontein. Pakiso, how different are the trials that are taking place at the ICC now from the Rwandan tribunals and the former Yugoslavia tribunals on which Judge Navi Pillay served?
Well, in terms of the law, the trials are the same. They are investigating and prosecuting crimes, war crimes, crimes against humanity and genocide that were committed in Rwanda as well as in Yugoslavia. The only difference is that those trials and the Rwanda tribunal was confined to only what happened in Rwanda, and the Yugoslavia tribunal investigations and prosecutions are confined only to what happened in Yugoslavia at that time. So that is, in terms of territorial jurisdiction, that is the only difference that they have, that they are only confined, they can only look into crimes that were committed in those territories, because those tribunals were created specifically to look at the incidents into those situations. The ICC, on the other hand, given the mandate that it has, given the number of states parties that have ratified the ICC statute, has got jurisdiction in all the countries that have ratified the ICC statute. So in terms of the law is the same. They are trying the same crimes. They are using, and in fact, ICC is benefiting a lot from the experience as well as the decisions of these tribunals. Judge Pillay herself, in some of the landmark decisions that she said on in the Rwanda tribunal, those decisions are now part and parcel of the law of the ICC, and the ICC always looks for that jurisprudence as well as guidance from those tribunals as precursors of the ICC. In fact, it has always been said that those two tribunals facilitated the establishment of the ICC. It was in fact realized that now you cannot be creating these ad hoc tribunals for each and every incident that happens. You need to have an permanent institution where, if these crimes are committed, then you'll have a standing tribunal that can investigate and prosecute them as and when they occur. Only other difference with them is that now, in those tribunals, the tribunal itself has got primacy. It has got primacy over national jurisdictions, whereas in the ICC, it is the courts themselves which have got, it is the national jurisdictions which have got primacy, and that the ICC can only intervene if and when the states themselves are either unwilling or unable to prosecute. That's the main difference that you have with these tribunals.
Judge Pillay, do you want to add to what Pakiso has said?
Well, Pakiso has correctly described the differences. In my view, if the Security Council had not set up the ad hoc tribunal for former Yugoslavia, you wouldn't have got a tribunal for Rwanda. So each one creates a precedent, and both those tribunals created the premise for the world's first permanent court, that's the ICC. What I want to say, since I served for 8.5 years on the Rwanda tribunal, is what great cooperation we got from all the states in Africa who transferred high-profile suspects who were in their countries, like Kenya, Cameroon, and they handed them over to the tribunal rather than to Rwanda, because they preferred an independent body to try these individuals.
Pakiso, quickly, let's go into the meat of this discussion. We have been joined by Professor Guto here. What is the issue around the referrals vis-a-vis the Kenyan story when there was violence around the elections, the last elections in Kenya?
I think we need to go back in history on what happened in Kenya. You had the post-election violence in Kenya, and there was a cry out for justice resulting from those post-election violence. Kofi Annan was tasked to go and to look into those situations. And after various discussions with the various parties in Kenya, they agreed that the post-election violence has to be addressed. There were to be reconciliation mechanisms, but on top of that, there should be justice. Now, the Kenyans, through Kofi Annan, were given a chance to say, even though you are a state party to the ICC, you have got primacy to investigate and prosecute these crimes as Kenyans. Various efforts were made within Kenya to try and establish a tribunal or at least some mechanism that would investigate and prosecute these crimes. Parliament in Kenya tried to pass laws and to create a court that would investigate and prosecute these crimes. Unfortunately, that came to nothing. And it was only after lengthy discussions, in fact, after consultations between the then prosecutor, Luis Moreno Ocampo, and the then government in Kenya, then the government said, we are not able or we are not willing to investigate and prosecute these crimes. You, prosecutor, go ahead and investigate and prosecute these crimes. And until then, there was cooperation, there was consultation, there was working together between the court and the government of Kenya. In fact, the mantra in Kenya was, don't be vague, go to The Hague, because everybody believed that you could not get justice in Kenya and that the ICC was the only place where justice could be obtained for the violence that occurred in Kenya, for post-election violence that occurred in Kenya. It was only after the names of the suspects were released that we saw a turnaround in the Kenyan reaction to the ICC. Until then, it was cooperation, it was working together, it was understanding, and it was full support for the work of the ICC in Kenya, because everybody in Kenya did believe that you could not get justice in Kenya unless you had the ICC as an external actor investigating and prosecuting these crimes.
Let's get another view. Let's get the view from Professor Guto, who I believe is Kenyan. Professor Guto, a country like Kenya, which we believe, all of us, is a country that upholds the rule of law. What happened in this case?
Well, I'm Kenyan by birth. I'm a South African citizen now. Let us go back and really say what was already explained, that we had a situation where crimes were committed. We still have people in locations of internally displaced people in Rift Valley. And at the time when the crime was committed, the current president, Uhuru Kenyatta, was not the president at the time. The current vice president, Ruto, was not the vice president of the country at the time.
Even though both were in government?
Yeah.
In opposition?
Yeah, they were in opposition to each other. And what we have now really is a situation where the two leaders came to a pact in the elections of 2013 to say they are bringing peace, but after they took over, they won the elections, a bit controversially, but they did. Now, after that, what they are trying to project is able to persuade the African Union to say when people are in office, they should not be tried. So the Kenyan situation is one where African leaders using the African Union are trying really to get a license to kill and impunity for themselves while they are in office. Now, the danger of that is that it will mean many leaders who commit very serious crimes of international proportions will not want to leave office, because if they leave office, they will be tried. While they are in office, they will feel free.
Let us come back to, let's go to a break, and when we come back, we'll explore this issue leading to what the African Union, a decision the African Union took in October last year. Don't go away, we'll be back right after this.
The shortage of nurses places those nurses who are working under such pressure.
To have one registered nurse looking after a ward full of patients, of over 40 patients, is unreasonable.
But Africa has made tremendous progress. In the year 2012, there were only 50,000 children. 50,000 children too many, but only 50,000 children that died of measles in the whole of Africa, compared to 330,000 in the year 2000.
For all your health issues, join Dr. Sello every Saturday, 9 to 10 a.m. CAT.
Welcome back. Let me go straight to Judge Pillay. Judge Pillay, this issue of Kenya, did it come to the Human Rights Commission of the UN?
No, it did not, but I had discussions with the then Minister of Justice, and now as High Commissioner for Human Rights, I urged him to have Parliament make a decision to hold national investigation. So they had ample opportunity to have these investigated nationally. And as Professor Guto has said, as soon as they found that it's the current leaders who are on trial, they want to push back on their ratification of the Rome Statute. The Milosevic is an example of a serving head who was put on trial. In the Rwanda tribunal, we had the Prime Minister of the interim government. If you look at Article 4A of the Constituent Statute of the African Union, it is very clear that they are committed to ending impunity for these serious crimes, but they make no exemptions. Now what we're seeing by this African Union's recent amendment, that they're providing exemptions for serving heads. And that makes a mockery of the principle of impunity.
Exactly. Let me come back to Professor Guto. Professor Guto, yes, as Judge Pillay pointing out there, with similarly with this hostile attitude of the continental body, the AU, they have found foundational doctrine, mainly Article 4, as the judge said there, that of the Constitutive Act of the AU, mandating the continental body to intervene in respect of grave circumstances, namely war crimes, genocide, and crimes against humanity. Why is the AU turning its back on these kind of things?
Well, it's not only those. In Maputo, they added those who change government through unconstitutional means to those other three areas where the continent or the AU would intervene. But secondly, it is not only that Kenya had ratified the Rome Statute of International Criminal Court, it had actually also enacted a law in the country to domesticate that, which means it was committed to trying those type of cases. Thirdly, the Kenyan Constitution of 2010 are very clear that no matter what office you occupy, immunity does not reside where international criminal justice is in place. So Kenya is actually at this particular moment defying its own constitution, defying a treaty which is signed, of course, with support of the AU. So I think collectively the African leaders are responsible for pushing for impunity against very serious crimes that are in the Constitutive Act of the African Union, as Judge Pillay has correctly indicated. So I think that we are dealing here with a situation where, as Africans, we have to be able, Kenyan citizens must be able to say, we want to respect our constitution and we want to respect agreements which we have agreed on at international level. But of course, being a head of state and so on, we hear that witnesses, some of them have disappeared, some have been bribed, and therefore the International Criminal Court has also a difficulty on how do you get credible evidence that can actually lead to successful prosecutions when a head of state is in place and the people who are going to support the International Criminal Court are appointed by the president.
Let me quickly find a view from Pakiso in Bloemfontein. Pakiso, at a press briefing last week addressed by the president of the court, Judge Sen Hyung Song, and the prosecutor of the ICC, Madame Fatou Bensouda. Madame Bensouda said the indictment of the president of Kenya, President Uhuru Kenyatta, and his vice president, William Ruto, had to be withdrawn provisionally as many court witnesses had been intimidated and she did not have a case to place before the judges of the court. What happened to the witness protection process, as Professor Guto pointing out here, that some witnesses disappeared?
Well, just a correction then. The case against Vice President Ruto is ongoing. We have had difficulties and challenges with witnesses, but that case is still ongoing now, so it's still on track. It's still ongoing. The problem where we have where we have problems now is in the case of the President Kenyatta himself. In that case, what the prosecutor was saying is that at the current moment, she does not have evidence that can be sustained in court. She is therefore requesting the judges to postpone the case indefinitely for her to be able to collect the evidence. Kenya is a very noble situation. We have had various challenges, in particular relating to witness protection, witness intimidation, threats to witnesses, bribery to witnesses, all forms of interference that you can think of on an unprecedented nature. In addition to that, we have had to face the problem of cooperation with the government of Kenya. Unlike in many cases, all the evidence that we need is in Kenya. Most of it also is in the hands of the government of Kenya. Now, if you cannot get that evidence, as a prosecutor, you rely on the evidence, and there's nothing much you can do if you cannot get that evidence. If your witnesses are either killed, they are bribed, they are threatened, irrespective of what you do, as an institution, we are a mere microcosm. You cannot compete with the state machinery that is bent, or people who are bent on threatening and bribing witnesses. Even if you take witnesses out, they will be found. No matter where you hide them, no matter what you do, if you have got a relentless efforts for those witnesses to be found, to be intimidated, and to be for them to be threatened in one way or the other, then they will be found. And this is what has happened in Kenya. Witnesses were found from afar, not only in Kenya, but even those that were placed outside. They were found there, they were intimidated, they were bribed, and everything was done to make them to recant their testimony. So that is the problem that we are having now with respect to the Mr. Kenyatta's case, that we are not able to proceed with that case because simply as prosecutors, you cannot proceed to the judges and say that they should proceed with a case if you don't have the evidence. That is just the facts of this case now, as it stands now.
I will go back to Durban, but I first want to exhaust this issue of Kenya. Professor Guto, somebody was saying to me, this decision taken by the AU is no different from the decisions that were taken by the Organization of African Unity in protecting each other as leaders.
Well, I think there is some substance to what that opinion is, because the Organization of African Unity put forward the idea of national sovereignty, which means that a head of state or the nation had to deal with all the problems, no interference with other states within the organization. That was changed in 2000 when the Africa Union, the Constitutive Act, was adopted. It put aside to say, yes, national sovereignty is very important. However, there are exceptions. The exceptions are where there are war crimes, crimes against humanity, and so on, and later on, and constitutional change of government. So there was a departure, a clear departure from the past, but in practice they are trying to smuggle back this idea that national sovereignty means don't interfere with those who are in public office. So we are dealing here with a situation where Africa has 34 countries that have ratified
the Rome Statute.
Yes, and it is the largest region in the world who are members of the International Criminal Court, and yet we are trying to roll back, and they are using the case in Sudan and Kenya to try and push this idea forward. I think we need clear leadership on this continent that say when you ratify a treaty, you abide by it. When you have a constitution, you abide by it. And that is the problem that we are dealing with. Constitutions without constitutionalism, ratifying treaties and then pulling back and not meeting them. And I think we as Africans, we have a responsibility to engage the systems of leadership in our countries to respect the rule of law, locally and internationally.
Well, when we come back, we will pursue this issue. First of all, I just want to know from Pakiso Muchochoko down in Bloemfontein, when we come back, as to what is happening now to William Ruto's case, because that case has not been withdrawn, and thereafter we'll go into other human rights issues with Judge Pillay. Don't go away. We'll be back right after this. South Africans survived 2014.
Many of us actually were given bursaries by state-owned enterprises, but the state shrunk, telecom was privatized, and now you are sitting with huge unemployed people, but huge backlogs in terms of infrastructure that would develop the same young people.
It's in our hands, and our future is up to us. It's a tough year, and tough decisions will have to be made by the government. It's an election year, which makes it difficult to make tough decisions. I mean, it's tough to make tough decisions. It's especially tough in an election year.
That's Rights and Recourse, Sundays 2 p.m. on SABC News.
Africa is growing at a rapid rate.
A huge part of this African growth is technological innovation.
Like a group of students hard at work in Uganda developing tools that will save lives. Or an African-developed payment method making the public transport industry cashless in Kenya.
You book me through M-Pesa.
There are apps only for people who live here. And the continent is accepting the growth of modern technology usage in people's everyday lives.
The ICT revolution now belongs to Africa.
This is information that matters to us.
To find out a bit more about social media and technology news, join Ms. Phumelele Zondi every Sunday at 7:30 p.m.
Welcome back. And Pakiso down in Bloemfontein, can you tell us then, if this case against William Ruto, Vice President William Ruto, has not been withdrawn, when is this case coming to court?
Well, the case is in court now. It is proceeding.
It is proceeding? The
case that is, it is proceeding, yes. The prosecution is still leading its evidence. It is still calling witnesses. We expect that calling of the witnesses by the prosecution to be completed before the end of this year. And after that, it will be now the time for the defense to call its own defenses to refute the prosecution case. So that case is gone. It is in court. It is going ahead. The case that is not going ahead now, which was scheduled to go on the 7th of October, is that of Mr. Kenyatta.
But that case has not been withdrawn completely. Am I right?
Which one? The case of Mr. Kenyatta?
The case of President Kenyatta, yes.
Yes, the case of Mr. Kenyatta has not been withdrawn. What has happened is that, and as a result of the problems that we are having, firstly with cooperation as well as with witnesses, we are merely asking the judges to postpone this case in the hope that we are still going to be able to persuade the government of Kenya to cooperate with us, as well as now to get additional evidence that we require for us to be able to be in a position to proceed with this case. Remember that against Mr. Kenyatta, the allegation against him is that he facilitated the violence in Kenya. He financed that violence in Kenya. For us to prove that, we require Mr. Kenyatta's financial records. We require Mr. Kenyatta's telephone records. We require Mr. Kenyatta's land records. We require Mr. Kenyatta's registration of vehicles. This is all the information that is solely in the possession of the government of Kenya. And this is information that we have requested and which we have not been able to obtain, despite the Chamber's order that the information that we are requesting is relevant, it is material, and it is critical for our case. So in the face of non-cooperation by the government of Kenya in providing us with all this information, it becomes very difficult for any prosecutor to come to the court and present evidence when that evidence is not forthcoming. It is as a consequence of this that the prosecutor is asking for a postponement, not a withdrawal. He's asking for a postponement of this case in the hope that we can be able to obtain this information and be able to proceed and present it to the chambers as evidence.
Judge Pillay down in Durban, it would seem to me somewhere I read that there's been some geopolitical issues taking place where countries like the United States or United Kingdom were not forthcoming in persuading Kenya to come forward and put the case and allow the case to go forward to the ICC.
First, if I may, Mr. Mutesa, add to what Professor Guto said. It's very clear under international law that there can be no amnesty, no immunity for these serious crimes. And that principle comes to us from Nuremberg, which you started your program with earlier on. Now, this is not a referral where the prosecutor then goes back to the Security Council to report non-cooperation. As you know, the International Criminal Court is not a UN court, it's an independent court. It comes under the treaty. But we ask all states to urge the Kenyan government to cooperate with the International Criminal Court because of this principle of superior responsibility and no amnesty. So the call comes from people internationally to the government. These are very real problems that the prosecutor is facing, and therefore I hope that the members of the AU, who also support the principle of ending impunity for serious crimes, that they will convince the Kenyan government that there is a need for them to cooperate and comply with the order of the chamber, the trial chamber, to hand over this information that the prosecutor is seeking.
Judge Pillay, another issue that I wanted to raise before we come to an end of this program, we seem to be running out of time very quickly, issues of human rights pertaining to the Palestinians. The last time I spoke to the chief prosecutor of the ICC, she told me the Palestinians could not bring a case to the court as they were not recognized as a country. Now they have observer status at the United Nations. They can bring a case to the court. Why can't the Palestinians bring a case to the court? And I know the UN Human Rights Commission has dealt with this issue before.
Let me say that I have welcomed the status now given to Palestine. They can now be referred to as a state of Palestine and participate in the General Assembly and the Human Rights Council. I have welcomed the fact that they have signed up to various treaties. We have an office in Ramallah and they are cooperating with us to report to the various committees on those. What they haven't done is to ratify the Rome Statute. And I've heard behind the scenes that the politics are that they're hesitating to ratify the Rome Statute because they want to use that as leverage to get a settlement for peace in the Middle East.
We'll come back to that, George. We'll come back to that. We'll continue with this issue of Palestine when we come back. If you'd like to join us on today's discussion, please call us on 011 714 6918 or 6919 or tweet us at Rights and Recourse. We'll be back after the break.
Zoom into Africa. This is Mali. The president is Mr. Ibrahim Boubacar Keïta. Mali got independent from France on 20 June in 1960. The population is more than 16 million people. One of Mali's major languages spoken is Arabic. Monetary unit is CFA.
The Swaziland Tourism Authority invited Kaleidoscope on a media tour of what has become known as the Little Switzerland of Africa, the Kingdom of Swaziland. The Mantanga Waterfall is one of Swaziland's best known and most accessible waterfalls, as it can be seen within 50 meters.
That's Kaleidoscope, Sundays 5:30 p.m. on SABC News.
Welcome back, and I would like to go back to the issues around the Palestine. Let us hear, Pakisho, there was a discussion at the press conference I attended during the week between the chief prosecutor and the president of the court, and there was an issue around Palestine, question that was asked around Palestine. Could you please remind us perhaps what is the court's view around the Palestine issue?
Well, again, as Navi has indicated, since Palestine has now been recognized as a state by the United Nations, it has been given observer status. It is now up to Palestine to come to the ICC. Palestine has since then ratified a number of other treaties, but it has not ratified the ICC statute. We have engaged with the Palestinians. They have asked questions about the processes at the ICC. They have asked us about how they could engage the ICC and how they could refer the situation in Palestine to the ICC. We have provided them with that information. Up to now, they have not come back to us. Essentially, it is now for Palestine to decide what it wants to do. It is not for ICC to persuade them to do anything, but if they come to the ICC in accordance with the statute, either through a referral, through what is called Article 12.3 of the statute, or if they accede to the statute, then the ICC will do its part and follow the law in determining whether or not crimes have been committed in Palestine and who is responsible for those crimes. Until such time, the ICC is waiting to see what the Palestinians will do. But it is really up to the Palestinians to decide on that.
Judge Pillay, one of the things we've seen the outrage by the Prime Minister of the United Kingdom this afternoon, this morning, for instance, when he made the statements about the ISIS, about the beheading of the British citizen. But we didn't see the same outrage when it came to the death of thousands of Palestinians.
I agree with you. It's very painful to see states taking the sides of their friends. They should hold their friends to the same standards as they do their foes. In this case, the IS, where the coalition is taking action against them. But on this very important issue of Israeli operations in the Gaza, for instance, I myself have served as High Commissioner over 3 such operations. And each time the commissions of inquiry, including the 2009 so-called Goldstone Commission have all recommended referral or investigations by the International Criminal Court. They first urged Israel to investigate the killings of civilians, damage to buildings, the killing of children. So it is a biased view to express outrage of some civilians and not others. All of them are human beings and all are entitled to protection of their human rights.
Professor, one of the things that I have alluded to was many Africans were saying this is the end of the ICC after the Kenyans used this bullock called the AU not to go and appear before the ICC. Is that the case? What are the other fundamental problems in Kenya around this issue?
I think the Kenyan one should be combined with that of the US. First of all, the US is hostile to the International Criminal Court. It has not ratified and it will not ratify the Rome Statute. But it uses the Security Council to send some states there. Kenya is one of them where the US is more or less protecting Kenya under the guise that Kenya is fighting international terrorism. The same thing with Israel. Israel is more or less a satellite state of the US. The US is funding even the killing of the Palestinians and so on. So I think we need to be clear about that. But the question of Palestine is that you can go to the court, International Criminal Court, by the state referring the matter. You can go there by the Security Council referring the matter. But the prosecutor also has an independent authority to be able to initiate a case. So it is not as if nothing can be done about Israel's massacres in the Palestine.
Final word quickly, Mr. Muchachoko.
Just a correction there. Indeed, the prosecutor has got a discretion to investigate on her own, but she can only do that in a state party. Palestine or Israel are not state parties to the ICC, so there's nothing that the ICC can do in that regard. Regarding the involvement of the Security Council, I think one thing we should realize is that now there is a provision in the statute which empowers the Security Council to refer the situation to the ICC. It was a carefully crafted provision in that statute, but the statute is in the hands of the state parties themselves. If the state parties, with the benefit of hindsight, now realize that the Article 16 referral is no longer palatable and that therefore they should deny the US and the United States Security Council the power to refer situations to the ICC, then it is for the state parties to do that.
Mr. Pogiso, Mr. Mchochogo, thank you very much. We have run out of time on this discussion. Probably we have to have this discussion again at some stage. During their visit to South Africa, the ICC officials called for greater support for the court. They reiterated the importance of our collective duty to never neglect the calls of victims whose rights and dignity have been trampled on by mass crimes. Today, thousands of African victims continue to suffer the brunt of mass atrocities. The ICC encourages and supports all genuine efforts of all national level aimed at bringing those to justice, those who allegedly are responsible for the commission of mass crimes. This has been Rights and Recourse. This program is repeated at 10 tonight and at 5 in the morning. The views expressed on this program are not necessarily those of the SABC. Good afternoon.
Have we seen the last of you in politics?
I don't know. No, I'm just okay now with the work that I'm doing. Let me just do one thing at a time. So I don't have any plans for politics.
Watch Question Time with me, Mpho Tsedu, Monday to Thursday at 5:30 p.m. on the SABC News Channel.
The Swaziland Tourism Authority invited Kaleidoscope on a media tour of what has become known as the Little Switzerland of Africa, the Kingdom of Swaziland. The Mantanga waterfall is one of Swaziland's best known and most accessible waterfalls, as it can be seen within 50 meters.
That's Kaleidoscope, Sundays